there can be ways of putting that.
You have more experience in dealing criminal cases than both of us, but
My lords.
so you can prove your submission. Come tomorrow. You may, if you can.
It's under section
so you are ready
304.
on merits.
My lords.
You are ready on merits.
Lords.
All right.
Asked me to go through this Preetpal Singh judgment in paragraph 38 and then address the court. Lords, for my satisfaction also, I just went through the entire judgment, Lords, this Preetpal Singh once again. Lords, I found that in the entire, right from paragraph 11, 12 to 21, the Honorable Supreme Court has discussed the merits of the case. As in, Lords, each witness, fourth witness, the defense witness, the post-mortem report, all those things have been discussed in detail. And not only that, Lords, when they are talking about an order granting bail which was set aside, the basic ground was that order being short, cryptic and non-speaking. So, Lords, not only this judgment, Lords, but other judgments, Lord, be it Anurag Beta's case or Kashmira Singh case or Lord Chandrasekhar Bharti of our own Honorable High Court, Lords, everywhere, Lords, this fact is there that cogent reasons and some indication, Lords, if my Lord would only permit me, Lords, even in this, I am placing from this very judgment, Lords, Preetpal Singh. Lords, this judgment has also considered, Lords, KC Sarkar's case in paragraph 30 of this judgment. Lord, even KC Sarkar was, it has been held in paragraph 11. The law in regard to grant or refusal of bail is very settled. The court granting bail should exercise its discretion in a judicious manner and not as a matter of course. Though at the stage of granting bail, a detailed examination of evidence and elaborate documentation of the merits of the case need not be undertaken. But there is a need to indicate in such orders reasons for prima facie concluding why bail was being granted, particularly where the accused is charged of having committed a serious offence. An order devoid of such reasons would suffer from non-application of mind. Lords, my humble submission before your Lordships would be that, Lords, I understand that even Kashmira Singh's case, all those cases lay down this principle that when there is, the case cannot be heard within a measurable distance of time, then in that case, Lords, and the hearing is not possible in a likely in the near future, then bail may be granted. So all those reasons have to be recorded. But it is not that, Lords, only those reasons are only sufficient, Lords, and it is not said that, it is said some reasons have to be indicated. So those reasons would only be a delay or
those reasons
would only amount to reasons of delay in the case being taken up, or the accused has never misused the liberty while he was on bail. It is not that.
No,
not that
even if the appellant is in a position to demonstrate,
Lordships, Lord, a patent infirmity,
that the finding is patently erroneous.
My lords, oblige
then
Lords.
even on the date of admission,
My lords,
or immediately after receipt of the LCR,
Lordships,
the court may grant bail.
Lordships,
So
Lord,
lapse of time is an additional factor. For consideration for the grant of.
Absolutely.
So there are 2-3 things. One, reason has to be assigned.
Lordships,
Two, according to you, the discretion has to be exercised in judicious manner.
Judicious manner.
What is judicious manner? So that is there in paragraph 38. That is the factor. That is how the discretion has to be exercised.
Lordships, Lords, I was just going through some other judgments also, Lords. Although, Lords, the judgment is before this is of 2020. Lords, 2009
that
judgment.
That is the whole difficulty, madam. We
Lords,
are facing. It is not that only you
Lords,
are facing.
Lords, I understand. I understand, my Lords.
The
constraint.
That is an aspect which
Lordships,
that has never been the standard for considering
Lordships,
an application for bail. But now when the Supreme Court says, and in very clear terms, now you are saying the order must be reasoned, all right, the order must disclose application of mind, the circumstance, because the presumption of innocence goes after the conviction.
After the conviction,
so once the conviction is recorded, the court has to assign reasons why he should be released on bail.
Lordships,
despite conviction.
Despite. Lords, that one line in paragraph 38 is creating the.
That it should be exercised in judicious manner,
Lordships,
not in perfunctory manner.
Well,
So what is that judicious manner? That judicious manner is there in paragraph 38.
paragraph. Lords,
That is the whole
that.
difficulty.
Otherwise, also, Lords, there had been a series of judgments, Lord, relating to this, where it was being said that order should be reasoned and should not be cryptic and all those
So
things.
many,
So
because I
many of
know
them,
there is
Lords.
no problem,
Lordships, Lord.
and this has been the practice
My Lords.
on this
But
court,
one line
that
here in paragraph
that
38.
before granting bail, the courts record reasons.
Lordships, my Lord.
We record reasons
My Lords.
while
Definitely,
granting.
definitely, my Lord.
So
Those reasons are recorded,
yes,
my Lords.
reasons are recorded. Reasons have to be recorded. Reasons are recorded.
My Lords.
But when it says that it should be done in judicious manner, and what is judicious manner, that has been explained in paragraph 38, then yes, therefore, we, the moment a lawyer stands up to press an application for bail during the pendency of appeal,
My Lords.
he or she should be in a position to start with submission that there is patent illegality.
Infirmity in the-
There is
in
the
the
patently, the
judgment of-
finding is patently erroneous because of this reason.
Because of this, my Lords. Absolutely. That is what has been very much clarified in this judgment, Lords.
And that,
Lords,
once you are able to patent, a finding may be patently erroneous. If say, say you can demonstrate that you are entitled to benefit of doubt in the facts and circumstances of the case, which has not been given.
given to you.
All right, and therefore the finding is patently erroneous.
Erroneous.
So there may be
Ways, and there can be ways of putting that.
you have more experience in dealing criminal cases than both of us, but
My Lords.
so you can
Still have
either
to learn.
improve your submission, come
Lordships.
tomorrow. You may, if you can, make out a case that the finding is patently erroneous. we will
Lords,
see.
I'll try to address. Although, Lords, this notwithstanding, Lords, obviously this judgment is there, Lords, which is there before your Lordships also, and which is before us also, Lords. So we
Fine,
cannot
sir.
exceed to what has been laid down. But, Lords, for academic consideration, Lords, it was a fact that appeal, Lords, is a continuation of trial. So,
Right.
Lords, one thing, Lord, is I'm just speaking my
Right,
mind
right,
out, Lord.
right.
What irks me is not that some points which become so relevant at the time when the appeal is being heard, those points will not be, and if they are not patently so much illegal that we can submit at the stage of 389, that is slightly, Lords, some grey area is there, Lords, because at those very points we are free to demonstrate when the appeal is being heard. Since appeal is a continuation of trial, we are demonstrating, we are arguing everything at the time of hearing. But when at the time of at the stage of 389, we still need to wait for 6 or 7 years of custody to point out other factors also, which could probably, Lords, weigh with your Lordships, Lord.
No, even on the first day, when your appeal is taken up, when you press your application for bail,
My Lords.
you can say that, see, this is the patent illegality. The finding is patently erroneous.
Lordships,
The
Lord.
conviction is bad for this reason. One point you may take you. After recording reasons, the court may grant you bail.
Fine.
So if you can prepare yourself on that line
Lordships.
to point out one patent illegality for this court to consider for consideration of your application for bail. we
Lords,
will see.
I'll try. What I can do best
Try.
with the brief, but I've
You try, and at least
Lordships.
now in view of that observation, the bar should be ready while addressing the court
Absolutely.
for the purpose of suspension of sentence.
Lordships. Lordships. Lord, this is a case in which, Lord, the
See.
conviction is under
So
section
you are ready on
304.
merits.
My Lord.
You are ready on merits.
Lordships.
All right.
304B,
So
Lords.
you are in. This is 304B.
Yes, Lord. The husband, the appellant is the husband, Lord, sole appellant.
Yes.
Sentence for life.
Yes.
One more impediment which I face, my Lord, that the prayer for bail was earlier rejected on 27/11/2018, and
Then-
this is an IA interlocutory application, Lords, on Annexure 1 at page 7. Order dated 27/11/2018. My prayer for bail while appealing the admitting the appeal, my lord. After that, the prayer for bail was rejected. Although the order only says, my lords,
Then
that
what
we
can
are
be done?
Lordship,
Nothing
taking
can
note
be
of the
done.
evidences that has come against him in course of trial, accordingly his prayer for bail stands rejected. This is what was laid down.
Since when
Lords,
you are in custody?
I am in custody since 23/8/2016, which is almost 6 years.
6
Lords, and
years.
taking aid of Kashmira Singh's judgment, my lord, it clearly says 5 or 6 years. That is what has been said in Kashmira Singh's case, my lord. At least 5 or 6 years, if a person is in custody and there is no likelihood of the appeal being taken up, then the suspension of sentence may be considered, my lords. That fact has been laid down in paragraph 2 of Kashmira
But
Singh's judgment.
in the
Lordships.
subsequent
Uh,
judgment of this division bench in case of Suddu Kumar, 7 years.
Sudhu Kumar, yes, that is my lord's judgment. I've gone
Yes.
through that. My lord's considering other judgments also. That is, my lords has considered.
Wait for some time then.
Not only one point that I was trying. If it can have any cut any ice with my lords, lords, the it is a case under section 304B, and whatever the witnesses who have come are all family members. Now, lords, besides that, the defense has come up with a specific case of a snake bite. Lords, the post-mortem report also shows it does not indicate any kind of, earlier also there was no complaint of any torture, physical assault, no soon before cruelty of death. That ingredient of section 304B is also not very much made out. Now, lords, so far as the injury, the doctor also finds that there is no injury on the dead body. Now, the only thing is that he finds froth. So, therefore, the viscera is reserved and sent to the FSL. And the doctor has been asked a specific question wherein he said that this can happen through a snake bite also. There's a defense witness also who has come, and the IO also, the most important witness, the investigating officer, says that during course of investigation, the witnesses have told him that in the night when she had gone out for easing herself, she had got a snake bite, and nobody was talking about all these assault and things like that. This has come in the trial, the family members. What the incriminating evidence which has come against this appellant, lords, is during the course of trial. Once the evidences were there, my lords, depositions were going on, then, my lords, the FSL report comes in the court. And in this FSL report, which has been marked as Exhibit 5, my lords, it is said that sulfos was detected, which is a poisonous substance. So this was the main ground for the court below for passing this judgment against me, because this had weighed heavily with the learned court below. Now, my lords, my only submission was this, that even in the judgment, I do not have to go to the evidence to show before my lords. In the judgment itself, it has been indicated, my lords, in paragraph 11, page 10 of the judgment, that there is 7 days of delay in sending the viscera to the FSL.
Madam, the question is,
Lordships.
What are the ingredients of 304B?
Lords, the major ingredients, lords, I cannot run away with, lords. I cannot run away from the major ingredients, and I realize that the onus also is on me. Therefore, the defense had been taken, and to a certain extent, lord, that defense has been pushed forward also during the trial.
So, if you can make out a case that the prosecution failed to establish that there was no demand of dowry soon before the death of the deceased, then you can make out a case.
No, that is true, but the family members have come and said that, so I cannot run away from that situation.
So only two things are to be established
For
to establish an offence under section 3 and
4B.
Demand of dowry, and then
Cruelty soon before the death. 7 years of marriage is
death.
there, lords.
Lords,
may I make a prayer, lords? The same, because 6 years, almost 6 years have passed, lords. So on completion of lords 7 years, if my considering my lord's judgment, Lord Sudhu Kumar judgment in that light, lord, if
all right. We are not inclined to accept such submission for the present. IA number so and so is accordingly rejected. It's up next. It is in the peculiar facts and circumstances of the present appeal, it is observed that the appellant shall be at liberty to take steps for early hearing of the appeal by making an application. That's all. If, despite efforts having been taken for early hearing of the appeal, comma, the appeal is not taken up for final hearing, the appellant shall be at liberty to renew his prayer for bail after 6 months. There is one of... All right.
Obliged.